Welcome to our virtual Justice on the Block Legal Information Clinic. This clinic is part of the virtual series, Know Your Children's Education Rights. This session, we're going to be talking about the new parental rights bill in Florida. I am Stephanie Johnson. I'm the managing attorney at Legal Services in North Florida. And this is Cheryl Sadler, who is our education advocate with Legal Services in North Florida. So just quickly, a couple housekeeping notes. This video provides legal information and should not be considered in any way as legal advice. This video does not create an attorney-client relationship or substitute legal advice that you've already been given. You may have defenses that we haven't discussed here, so seeking out an attorney for help is always the best thing to do. For more information about legal services, you can go to www.lsnf.org or call 850-385-9007. So Cheryl, there's a lot of news coverage about Don't Say Gay in schools. What is that about?
Well, this session, session 22, so it ended in April, the Florida legislature passed a bill, which is now law, called Parental Rights in Education. So supporters say the law's intention is to keep parents more involved in the education of their children. But opponents argue it could ban teachers from encouraging the children of same-sex couples from speaking about their families. And it could create an environment in which those children and LGBT students themselves feel stigmatized and isolated.
The bill bans instruction on sexual orientation or gender identity in kindergarten to third grade. Were elementary school teachers teaching about sex?
No, that's actually part of the conversation about this new law. Teaching about any kind of sex and sexuality is not required in Florida elementary schools. And frankly, schools are already struggling to try to teach everything that is required. So there's not a lot of extra stuff that gets in there. In grades 6 to 12, so middle schools, schools are required to teach only one thing, and that's the benefits of sexual abstinence or not having sex. So, in addition to that, school boards can also decide whether to teach about reproductive health and disease. And of course, parents have always been able to opt their children specifically out of this instruction.
Okay, so if elementary schools aren't teaching about sex, what was the concern?
Well, yeah, that's an interesting question. So, opponents of the law say this is an unnecessary law, but now we have a law on the books that says no teaching about sex. And so, what does that mean to teach? For younger students, does instruction mean maybe not teaching books with LGBTQ plus characters? What about classroom conversations that children initiate? What about a picture of a same sex spouse on a teacher's desk? Can any of that be considered instruction? And this is where we get to what's called a chilling effect. So, chilling effect is where people don't do things that might not be illegal, but they're worried that they could get in trouble. And this is really important with this law because the law gives parents specifically permission to sue school districts if they think the law is being broken. And it also requires school districts to pay those costs. So that's a big deal.
And what about the older students? Does the law affect the older students?
Right. And it gets really, I thought it was tricky before, it gets even trickier now. So beyond K to 3, the law says, and I'm going to quote, instruction on sexual orientation or gender identity may not occur in a manner that is not age appropriate or developmentally appropriate for students in accordance with state standards. Well, first, we already know that state standards don't address sex and sexuality because if they did, teachers would be teaching it. But also, we don't know what those things mean. What is age appropriate or developmentally appropriate? And you might guess that people have different opinions on that. So right now, we're waiting for the Florida Department of Education to define what age appropriate and developmentally appropriate mean. But it certainly could mean not teaching students about LGBTQ figures or historical events.
And does the law go beyond teaching about sex and sexuality?
Oh, sure. And again, it just gets more and more complicated. There are several requirements about mental health. And these are a concern for all students, but we know that LGBTQ plus students can be especially vulnerable. And we're going to put some links in the chat that are supports for those students. For example, we know that there are mental health concerns. We know that there is a potential for a higher rate of suicide. So it requires school districts to notify parents if a child gets services or is being monitored, and please don't ask me what that means, for their mental, emotional, or physical health or well-being. And the concern is here, what happens if a student goes to a school counselor and says they're gay or that they think they might be gay? We call that questioning. In the past, schools have been a safe space for students who might not be comfortable having these discussions with their families. So the State Board of Education has told districts, this includes, the law includes students using different pronouns. It includes bathroom use. It includes locker room use, gender-specific groups, and overnight field trips where there's room assignments. So if a student requests different pronouns or to use a different locker room, parents may need to be notified. So districts right now can't have procedures that or forms or anything that prohibit school staff from notifying a parent about these things or discouraging a student from telling their parents. And there's only one exception, and that's if the school reasonably believes that disclosure would lead to abuse, abandonment, or neglect. And then there's another thing. Any training that a district provides to its student support services staff, that's counselors, mental health folks, has to comply with guidelines, standards, and frameworks that the Department of Education is developing. And they're not even going to be ready until next summer. And third, and finally, at the beginning of each school year, parents have to be notified of each and every healthcare service that the school offers, and they have to be able to decline any service. That's already in place, but I think this is much more specific. So I think, Steph, we've talked about for your son, you get a form every year that says, that the school is allowed to give health care to your child in an emergency. And this would be a long list of things that they would or would not be allowed to do.
Wow, that's a lot. So what is the current status of the implementation of this law?
Well, the law went into effect in July 1st, and the Education Department actually collected all the policies of every school district and reviewed them. And in November, it sent letters to 10 districts, so 10 out of 73, that said their policies didn't comply with the new law. And in December, actually just a few days ago, the State Board of Education held a public meeting that criticized these districts and said, you need to really hurry up and get these policies on the books. And of course, a school district doesn't just develop a policy and there it is. They have to have public hearings. They have to vote on it. So there's local processes where people can, figure out what's going on where they live. At the same time, there is, of course, a lawsuit seeking to undo this law. And we will see what happens. This is another one of those to be continued.
Okay, another to be continued. Lots of those. All right, thank you very much, Cheryl. And like Cheryl said, we'll be attaching some links to this, and stay tuned.